but he didn't look at the connections where it was actually became worse, and actually where the leaking was worse and where the ultimate failure actually occurred. Mr. Wood's report that year concluded that there was no structural concerns with the mall at all, and that he had not observed loss of section, despite the fact that he didn't take any detailed measurements. And Mr. Wood did not anywhere in his report warn against the consequences should the roof continue to leak. So by 2010, 2011, Eastwood started to get concerned about the viability of the mall and the hotel, and they decided they want to sell, but maybe not surprisingly, they're having a little bit of trouble getting anybody to buy it. They hire one potential purchaser hires another engineering firm, and that engineering firm in late 2009 quickly concludes that the parking deck was in really bad shape and needed complete repair. So that potential buyer walked away. RBC does another follow-up report in 2010 and says that that there's a possibility for structural damage. And in addition, Keith Moyer, who is a citizen member of the city's Economic Development Advisory, stated to the owners that given the decades of water mixed with road salt and other contaminants penetrating into the slab, one may have serious concerns as to the continued viability of the reinforcing steel. And then in May 2011, a co-owner of a restaurant in the mall called Hungry Jack's came to work, and there was actual concrete falling out of the concrete slabs and the roofing material into the restaurant, which he notified the city and the owner of, and nobody did it. So in 2000, that brings us to 2012, and by then the tenants are refusing to pay. Shoppers Drug Mart leaves, vacates the mall. Scotiabank vacates the mall. Zellers doesn't notice a default because of all the problems. The library is still asking to go, but can't. And then two final inspections were done. One by the Ministry of Labor because somebody complained about the conditions in the mall. And the second one was concluded on April 12th, 2012 by Mr. Wood again, who did the first inspection. With respect to that second report that Mr. Wood does, Mr. Wood conducted the inspection while his license was under suspension. He was able to continue the work, but only on the condition that his report was reviewed by a professional engineer. Mr. Wood took Eastwood on as a client, or the owner on as a client, despite the fact that he had been asked by his firm not to accept new clients. Mr. Wood inspected the areas he had reviewed in 2009. He noted the water capturing systems, which were the bladders and hoses I was telling you about earlier, rusted exterior walkways, missing ceiling tiles, and all of the leaks. But he saw no visual distress in any areas that could be visually inspected and shown by maintenance. He saw rusted steel beams, but took no measures on the basis of the visual assessment of corrosion only. He concluded there had been no loss of section. He made no attempts to uncover hidden areas, saying that he was not authorized to do so. He did not recommend more comprehensive inspections. He didn't express any sense of urgency about the need to fix the roof permanently. He then sought to have his report reviewed and signed by a gentleman by the name of Gregory Saunders, who was a professional engineer. They met for approximately 45 minutes, and Mr. Saunders signed Mr. Wood's report. Mr. Saunders never went to the mall himself and had never been there. He made no efforts to look at any previous reports, either by his firm or that his firm had prepared for the mall. More distressing, well, not that that's not all distressing, but more distressingly, after he had sealed the report, Mr. Wood, without telling him, went and showed the report to the owner, and the owner said, well, I don't like certain sections of that report, and he unilaterally changed it without going back to the engineer, and then delivered the report. So that final report was delivered May 3rd, 2012, and the mall collapsed June 23rd, 2012. So I wanted to give you all those facts, not because they're usual or anything. It's just that it's an incredible fact scenario that I've worked with engineering firms now for coming up on 12 years. It's the worst case scenario I've ever seen, but there are lessons to be learned from it. So these are some potential pitfalls. So in examining these issues and bringing to your attention, we're just looking at legal liabilities and ways you can protect yourself in the future. Structural assessments of existing buildings, specialist certification, supervising work are the things I'm going to talk about. So the current situation is that there's a lack of legislative requirements for structural engineering assessments of existing buildings. The building code requires that construction, enlargement, and alteration of buildings such as the Algo Center Mall be reviewed by an engineer. The purpose of that is to note deficiencies and alert the chief building officer. There's no such requirement though for existing buildings, so there's a gap in the legislation. With respect to structural with respect to what happened at Elliot Lake, I've gone over some of this, but to go over it again, the chief building officer issued an order to remedy the deficiencies to the mall owner, which included structural review by an engineer. The Algo Center was an existing building. The engineers conducted visual inspections only and did not conduct a full structural review of the building. There was no mandated standard for a structural assessment conducted on an existing building. The Elliot Lake Commission report recommends a province-wide minimum structural maintenance standard for all buildings in Ontario. This regulation, entitled the minimum structural maintenance standard, should require that all buildings be watertight, structurally sound, and not unsafe. Under the Professional Engineers Act, performance standards can be enacted under regulation. A performance standard is binding and enforceable. It is professional misconduct to fall below the requirements laid out in the performance standard. The Elliot Lake Inquiry report also recommended that the PEO enact a performance standard for requirements of the minimum structural maintenance standard inspection. And then upon completion of the inspection, the report recommends that the engineer complete a structural adequacy report that details whether the building meets the minimum structural standard, and if not, the necessary steps required to bring it into compliance. It's also recommended that the report be completed by a structural engineer specialist as designated by the PEO. This report should be provided to the owner of the building as well as a public registry. And furthermore, if the building does not meet the minimum structural maintenance standard, the report should also be filed by the municipal CBO, who will then have the power to enforce the required repairs. So in the interim, and as I said at the beginning, none of these things are enforced yet. These are just recommendations. So in the interim, some things that you can do as best practices or things to keep in mind is to gather all the documentation related to the existing building, such as plans and previous reports. Present a report of your findings to your client and file a copy with the CBO of the municipality. And in the report, provide clear descriptions of what areas were inspected, what areas were not inspected, and why they weren't inspected. The next issue that was brought up in the commission report was specialist certification. So under the Professional Engineers Act, the council of the PEO has the power to make regulations providing for a specialist designation, and the qualifications and requirements to achieve this specialization. There's currently no regulations passed under this power. The structural assessments of large public buildings such as the mall, Algo Mall, directly affect public safety. It's interesting to note that the inquiry report recommends that the structural adequacy report be completed by a structural engineer specialist. However, there's no current specialization and there's no recommendation for the creation of such a designation in the report. I believe the PEO council, I may have this wrong, I think in the PEO submissions, they suggest creating a structural engineering specialist designation pursuant to the powers of the PEA. The requirements for obtaining the status should include a registered PEng in Ontario with good standing, minimum number of years of structural engineering experience, and completion of specified exams. The Elliot Lake Inquiry Report does recommend that the PEO establish a system of mandatory continuing professional education for its members. So in the interim, again, for best practices, it's always best for the engineer to understand their limitations and be cautious in taking on work that is outside their area of practice. And don't be afraid to seek the assistance of other experienced colleagues when faced with a project that's outside your specialty. And seek their counsel and guidance. The next issue brought up is supervision of work. So under section 12 sub 1 of the PEA, it prohibits persons not licensed under the PEA from practicing professional engineering. However, there's some exceptions to that in the same section, section 12, where that section does not apply to prevent a person from doing an act that is within the practice of a professional engineer, where a professional engineer assumes responsibility for the services within the practice of professional engineering. So that basically means that anyone can perform any of these inspections so long as a licensed professional engineer assumes responsibility for their work. So that would be the case in this sense of Mr. Wood and Mr. Saunders. So again, with respect to Elliot Lake, the engineer who conducted the structural inspection of Algo Mall under the order to remedy had a suspended license. And most importantly, the licensee, the engineer, didn't attend the mall and simply relied on the suspended engineer's experience when signing off on the report. Now, in fairness, the report was also changed without his knowledge, so there was more problems than just that, but he didn't go to the site and he didn't investigate it all either. So recommendations and proposed changes with respect to the report. The report did not make any recommendations with respect to supervision of work by non-licensees, but submissions were made, again, by the associate engineers that a system close to the Law Society of Upper Canada's system be implemented for supervising non-licensees. So the system that they suggested was that a licensed professional engineer must assume complete responsibility for the provision of engineering services and must directly supervise all non-licensees. The engineer shall ensure that the non-licensee does not act without the professional engineer's instructions. The engineer shall review all tasks assigned to the non-licensee. The engineer shall assume responsibility for all the tasks assigned to the non-licensee, including documents prepared, and the engineer shall only assign tasks that the non-licensee is competent to perform. The inquiry report did recommend that the members of the PEO report any suspensions or revocations of their license to past and present clients, and it also recommended that the PEO update a website to allow the public to easily search the name of every licensee and import information such as discipline and professional conduct, which is again essentially the same system as the Law Society of Upper Canada has for lawyers, which I guess is why a judge recommended it. So where do we stand now? Basically, in the interim, to fill these gaps, you should always be thinking about best practices and some of the things I talked about in this presentation. I put that there's public outcry with respect to this. I like to think that there still is. There was when the Premier ordered the inquiry. I don't know what the political will is at this stage to implement the changes. The Commission itself has said that they'd like a working group struck that some sort of implementation of these requirements would be put into place from the release of the report, which was October 14th. So we'll see. I haven't heard anything yet. And then where are we headed? It looks like, and I think it's accepted in most of the submissions, that there are going to be more rules and regulations with respect to oversight and with respect to how visual inspections are conducted. And there's going to be, I think, more of a centralization of how reports are provided, i.e. the example of Halsell coming in 1998 and not knowing that in 1996, 94, and 91 everybody said that the mall was leaking. In all of the testimony that I heard, every engineer said, look, if I had known that this was an ongoing concern, it would have drawn my attention to these problems as opposed to me just walking in and saying, hey, can you do a quick visual inspection? I mean, if I'm looking at this room, looks good. I don't see any water stain, but that's what those visual inspections are doing. They're just walking around and looking for something that just really pops out. They weren't popping their heads in under the tiling or anything like that. So it was a very quick visual inspection. There's going to be, I think, more rules and regulations with respect to that. So again, how can you prepare? Just focus on best practices. When new regulations come out and new standards come out, watch for them if anything's implemented with respect to the Elliot Lake inquiry, and keep an eye on developments. So that's it. I'm more than happy to take anybody's questions. Sure.
Are there any criminal charges made at the end for anyone?
Yeah, Mr. Wood. Basically, if you look at the report, I'm sorry, I don't have the page section right in the head, but if you go on the first section of the report, if you want to really detail it, I just gave you the really broad overview of what happened with respect to Mr. Wood. If you look at the practices of Mr. Wood, basically a lot of the recommendations that the commission had were based on his actions. But it doesn't all just fall on him. I mean, he had an owner. He had gone into the second time he did the inspection. He already had some preconceived ideas because he'd done a previous inspection, so he kind of just cursorily went over most of the stuff he'd done in, I think, 2009, right? And he also had an owner that he sort of knew this is what he wants to hear. Not that that's the way to go, but he sort of did that too. So, but a lot of it falls on the owner as well. It's not just the engineer. The owners clearly, engineers went in. For the example, Halsell went in and said to the owners, do you have reports? And they had reports, but just nobody gave them, because there's no requirement.
Was there anything in the end with just Mr. Wood?
I know it was Wood for sure. I know Saunders was looked into, but I don't remember. It's all listed. The OPP did an extensive investigation previously. And it was weird. I had some clients do the OPP investigation, and then the commission, the OPP and the commission didn't talk. I don't know why. They didn't want to talk. So you had to kind of do the process all over again. But it was and you conduct those examinations in very different ways. I was much more hesitant to let my client talk. If it's you and we're sitting there in front of the OPP, it's not because they want good. They're not there to tell you did a great job and talk freely. I have to protect my client's interests. Whereas the commission, they're really not supposed to find liability, so you're able to talk a bit more freely. Now, if you go through the report, the commissioner pegs, Eastman, Nazarian, Wood, Saunders. He's pretty Halsell to a degree. He's very critical, but he doesn't say if they're criminally liable.
What was Mr. Wood's license under suspension?
It was filing a false report or something. I don't want to misspeak, but he had issues with one of his reports, and I'd have to go check again the transcript, but it was something like that. Professional misconduct. It had something to do with the report, but I'd have to check.